Sorry about that, but managed to reconvene.
I'm going to try and be relatively brief. I have a few points to make, just to pick up on some of the things. So none of those cases, Amina, Epson, Telford, Proxy, GD European, VTech, none of them are about GIR 6. And we haven't been shown a single case, because probably there haven't been any, in which you have subheadings with parts and accessories and a note referring to parts and accessories. I mean, it's an unusual case, and in cases such as this, one needs not just to copy cases that have no relevance, but to apply the law. And in my submission, if you accept that Note 3 is being disapplied in the context of skates, for example, there is no difference here, and principle must apply. And the result, as I've submitted, is perfectly plausible and sensible. The HSEN on GIR 6 that you were taken to, just to flag the one that refers to platinum, that describes a conflict between notes and subheading notes. But the explanatory note, as I showed you before in opening, also describes GIR 6 as disapplying as disapplying notes where there's a conflict between notes and subheading texts. That's the example that we've got. So there's no example of that, but that's what the GIR, the HSEN says. It can occur, and in my submission it's happening now. My learned friend said redundancy is not an issue in construing the combined nomenclature. That's a surprising submission. I submit. In one case, one of the cases that he cites himself, Proxon, shows that the Court of Justice is sensitive to the issue of redundancy. Page 170 of the first authorities bundle, tab 1, page 170. Tab 15, page 170, Proxon. So paragraph 27, the court says, well, if we adopt this interpretation, it effectively renders a subheading completely redundant. So, I mean, as one would expect, redundancy is a consideration, even for the Court of Justice. Pick up on some other points. My learned friend says, well, there's no difference between dolls and solely human dolls. I accept that there are some things which are clearly not dolls. Not everything is a doll, but there is a distinction between a solely human doll and a doll. That's why the wording is different in Chapter 95, and indeed, a case called Toy Biz demonstrates that. That's in the third authorities bundle, tab 49, and it's page 877.
And it's called Toy Biz.
Toy Biz. It's a US case.
Yes.
And what it shows.
Oh yes, I see.
Page 877. Or rather, 866. Well, let me take it to 877 first. It makes the point. Just allow you to read that paragraph.
What paragraph in the middle? 866.
The paragraph with yellow, yes.
I'm sorry, 877 or 866?
Page 877, I'll
Thank
take
you.
you to.
Yeah. And that sharp distinction wasn't always the case. 866 records the US
government's view according to the very top of 866, the submission is that dols means dols representing human beings. Which the court rejects on page 869. At the very bottom of page 869. Going on to page 870. It was a change in, a conscious change in wording. That point goes to the question of whether one applies note 3 to the 9503 heading as a whole. In my submission, doesn't really much matter whether dols is, whether we are dols or not. We are within the heading as a whole, and note 3 falls to be applied to that heading as a whole, as the Upper Tribunal correctly decided. You were taken to the permission skeleton and to some extracts from that. Of course, on our view of note 3, it was closer to what I say is the ordinary meaning of accessory, where you can be an accessory of different items. And that's why that permission skeleton said, well, if note 3 is can also be satisfied by use with items in different headings, then there is less of a divergence between parts and accessories and the note 3 wording. So that falls to be read in context. In terms of permission for raising GIR 6, and my submission, you haven't really heard any cogent answer to the points made on GIR 6. But in terms of why this was raised now, and whether permission should be given, well, my submission, firstly, it is within the existing grounds of appeal. So this is in the core bundle, grounds of appeal in the core bundle on page 14. And it's the third ground. Third ground is that note 3 does not alter the fact that if parts and accessories are expressly mentioned, then one applies those words. That has always been the case, right from the very beginning. However, before, the conflict was resolved, Appellant argued, was resolved by GIR 3. And now I'm saying it's GIR 3 and GIR 6. But throughout, it has always been necessary to make a finding, on our case, are these accessories or not? Not applying the note 3 test, but just applying the words as construed by the Supreme Court. That's always been our case. So no additional facts are required as a result of this ground. Indeed, this basis for this additional basis for this ground of appeal, just additional reason, but the ground is the same. No additional findings of fact. Indeed, that was the GIR 6 point was in the pleadings. So it was in the summary document that was exchanged with HMRC before the First-tier Tribunal decision, before the First-tier Tribunal hearing. It was a different counsel that did that. It's correct, it wasn't raised in the First-tier Tribunal, but it could, in principle, have been raised in closing submissions, and the trial would have been run on the basis that it could have been. In terms of additional evidence, there is none. I mean, we have always said these are parts and accessories. GIR 3 makes that a relevant point for you, the tribunal, to decide. Now we're saying GIR 6 is also reason why the plain wording of the DOL's subheading matters. It's not plausible to suggest additional evidence would have been needed to deal with that point. It's just simply fanciful. In terms of the factors for the court to consider, the authority is Pitalis, which is in the second authorities bundle, at tab 29, page 395.
Do we need to go to that?
Well, I think I'll just refer to
yes.
it. No, you don't need to.
No.
Point is there prejudice? Has the other party had an opportunity enough to meet it? Has he acted to his detriment on the faith of the earlier mission to raise it? And thirdly, can he be adequately protected in costs? If so, then the likelihood is it will be allowed as a ground of appeal. So that's dealing with GR 6. Now, on the question of accessories, it's correct that there is no finding that these were accessories, but we have argued throughout that there should have been a finding made, so that can't very well be held against the builder there. HMRC suggested that there was a finding by the First-tier Tribunal. They pointed to paragraph 177. But if you follow what the First-tier Tribunal says after paragraph 177, they only talk about note 3, and they say, well, note 3 requires us to ignore features even if they have no effect on use. And that's what note 3 requires. They don't say that's what the case law on parts and accessories requires. Indeed, if that were the case, that would be a very surprising result. So they forget about their alternative basis. And in their conclusions at paragraph 185 or 187, they don't refer to that at all. So it really was a decision based on note 3. And to the extent that's not right, well, it's my submission wrong as a matter of law. You've heard that there's some significance to be attached to the word accessory of. Well, my submission, you can't just focus on the word of, you've got to look at the word accessory. It's broad. And moreover, it's not accessory for, which might be said to indicate some sort of designed for test. It's of. Now, again, the combined nomenclature is capable of using the word accessory for if it wants to. And we have an example in Europlasty, which is in the first authorities bundle, tab 17, page 202. I'll just show you the wording. It's a wording from the combined, one of the headings of the combined nomenclature, page 202. Bottom there, note 2 to chapter 90 is CN states, subject to note 1 about parts and accessories for machines, apparatus. Now, I'd wager that that's not the only time that the combined nomenclature uses that. Here we have accessories of. But as I say, the main point is that accessory is a broad term. as Amina demonstrates. Single use, the issue of single use, I won't take up much time now, I've almost finished, maybe 5 minutes. Single use, even if it's right that as part and accessory, the ordinary term connotes a single main use, there is nothing to say that that main use can't be with articles which happen to find themselves in different subheadings. And if one is playing with a doll or an animal toy, it's the same use. It's use with a human-like toy. So it makes no sense to say that on an ordinary application of part and accessory, the dolls, the accessories are not being used. The accessories are not being used. It's not a single use that applies here. Finally, on shoes, because we're running out of time, what I'd like to do is just take you to my submissions on shoes and why this is a point of law, not of fact. That's at tab 4 of the core bundle, page 132. And rather than read that out, just invite your Lord and Ladyships to read ground 4, paragraphs 28 onwards.
Which paragraphs do you want us to read?
Paragraphs 28 through to 35. So my Lord and Ladies, that concludes my submissions. In essence, our case involves reading the words, applying them, not coming to prejudge result, just following the words, and we get to a result which in my submission makes perfect sense. And HMRC's involves not only bizarre results, but also striking out words left, right and centre. So my submission, respectful submission, the appeal should be allowed.
Well, thank you. Sorry, Mr.
My Lord, if you would assist, I wanted to say something brief on Toy Biz, but if you're not going to be
Oh, I suppose it is a new case, so
new case.
you're quite right. You have a right to respond on it.
Could I just say one?
Europlasty as well, if you...
Yes.
Yeah, Europlasty. Yes. So Toy Biz. So the context for Toy Biz is that it's being cited for the proposition that dolls in the heading mean something different from dolls in the subheading, which says human form only. This authority doesn't support that proposition at all. It's an American customs case which is concerned with, you will see from page 859, tab 49. Comparing, on page 2, the provisions of the historic tariff of the United States before it adopted the harmonized system. So TSUS is the old United States tariff, and HTSUS is the new harmonized system tariff. So when my learned friend refers you, as he did, to the two differences in provision between doles and doles referring to human creatures, they're not looking at the tariff provisions that you are, doles in the heading, doles representing human creatures in the subheading, and saying those are different. They're saying that the old TSUS at A69 said doles, and the new HTSUS said doles representing only human beings. So that is not a case interpreting the heading in the combined nomenclature for doles and saying that it has any wider meaning. And that is made clear by the HSENs at 851, which interpret the subheadings exactly in accordance with the submission I made, namely that doles in the ordinary dictionary definition are representations of human beings. Europlasty, the point there is that the formulation accessories for something means something markedly different from accessories of something. And I just don't accept that. That is such a slender basis for saying that one imports a use-based test and the other doesn't. It just doesn't work. In order to say that something is an accessory of something, you are necessarily saying something about the use to which that accessory is being put. And it's being put to use with something it's an accessory of, just as much as an accessory is being put to use with something that's an accessory for. So I say there's no decisive difference to be attached to those to that choice of wording. So that's all I want to say about Europlastic.
Thank you very much. Well, as you would anticipate, we're not going to give judgment this afternoon. In accordance with what has become the practice, I would expect that judgment will be delivered remotely rather than in a courtroom. But of course, even were judgments to be handed down in a courtroom, there would be no need for anyone to attend. As you would expect, you will be provided with the draft judgments in advance of hand down for you to correct our typing and English, but not to re-argue the case. And we would be grateful if you would seek to agree an order dealing with consequential matters before the handout. If there are points on which you disagree, we would like please brief written submissions on those, and we would expect to resolve the points in the order that we make. But thank you both, and indeed those supporting you, very much for your submissions and for coping with the fire alarm just before the end of them. So thank you very much.